Hello, everybody. Adam Parks here with another episode of Receivables Roundtable. Today, I'm here with my good friend, privacy expert, Kim Phan with the Troutman Pepper. How are you doing today, Kim?
I'm well, Adam. How are you?
I could not be better. It's another day in paradise. I cannot complain. I appreciate you coming on for a second time and having another chat with me today. I learned so much from our first encounter talking about data privacy that I have so many more questions to ask you, and I appreciate you coming back on the chat.
Of course, I love being on, love talking to you, and I'm hoping that your listeners will get a lot out of this conversation as well.
I have a feeling that they will. So, for anybody who has not been as lucky as me to become one of your friends through the years, could you tell everyone a little bit about yourself and how you got to the seat that you're in today?
Sure. So, again, my name's Kim Phan. I am a partner in the Washington, D.C. office of a national law firm, Troutman Pepper. I sit in our consumer financial services and privacy and cyber groups, and that's what I do. I provide uh, data protection counseling for financial institutions, whether or not that's banks or collectors or consumer reporting agencies, really just across the gamut of the financial ecosystem, and advise on, whether or not that is product development, consumer interactions, whether or not that's email, online, vendor oversight, really anything prior to a complaint being filed. When that
Mm.
happens, we have some great litigators that I'm happy to introduce you to, but I don't do that myself.
Fair enough. Could you tell everyone a little bit more about the firm itself and what you guys do from an overall standpoint?
Sure. So Troutman Pepper is a full service firm. We have 1,200 attorneys and 23 offices across the country, in a wide variety of areas, right? So anything that any company might need, whether or not that's tax, real estate, M&A, consumer financial services, privacy and cyber, we've got folks that do that and can help. Labor employment, housing. We have so many different and amazing folks at the firm that it is. If you have a question, I can find you the right person to answer it.
Well, with 1,200 attorneys, I would like to think that you guys have a little bit of expertise in just about everything. That's a big firm. So today, I had reached out to you. You had posted something recently about Americans with Disabilities Act and some of the changes that are taking place really across the web right now as it relates to ADA. And it kind of piqued my interest to be like, oh my God, I got to get Kim back on here and have another conversation. Can you tell us a little bit about how things are changing from an ADA perspective right now?
Sure. I mean, I think when most people think about the American with Disabilities Act, they think about like ramps in
Mhm.
stores and like that little dip in the sidewalk when you're walking on the street. But it goes beyond that to the internet as well. E-commerce engagements and interactions are super important with regard to making sure that that is a medium by which folks, even with disabilities, can engage with your organization and company. And there was a recognition, right, during COVID that the
Mhm.
vast majority of folks were engaging in business virtually. They were not going down to stores. They were not doing some of the things that they might have done in the before days, right?
Mhm.
And that is kept up in the after days, right? Like now that we're in the wake of COVID and folks are still starting to get back out into the marketplace, that still doesn't mean they don't want to do business online. It's just
Mhm.
faster, easier, and it is important to the U.S. government that the American with Disabilities Act be applied to electronic commerce as well. And so what recently came out will not actually impact the private sector directly, but is a new set of rules with regard to how the public sector, so
Mhm.
federal government agencies, state governmental entities, have to implement the American with Disabilities Act online. And we've known for quite some time that this was something that the Department of Justice, who has the enforcement authority with the ADA, was going to do. They've
Mhm.
hinted at it for a long time. That rulemaking has started up and stopped a couple of times. Like Trump
Mhm.
said, we're not doing that. And when President Biden picked it back up more recently, they were able to get the public sector rules in place, and that's what most recently came out. And the rules essentially say that for purposes of ADA compliance, that agencies should be deploying what's called the Web Content accessibility guidelines. It's a mouthful. WCAG, which is a standard that has been promoted by what's called the W3C Council, the World Wide Web Consortium. It's
Mhm.
an international nonprofit. And for a long time, this standard has been what across the industry has been considered sort of the baseline.
Mhm.
And now the DOJ has sort of memorialized that in an actual rulemaking that we are assuming for now is limited to the public sector, but we'll get to the private sector very soon.
Well, in 2019, we had the Robles versus Domino's case that kind of changed the dynamic of how we looked at accessibility from an online perspective, even in the private sector, because they made websites a place of public accommodation,
Mhm.
right? So it kind of changed the requirement on us to where it became something that we really needed to be focused on and something that we need to do. I want to say the Domino's ended up paying, I want to say it was about $29 million out for not being ADA accessible. And last I was researching a couple of weeks ago, I want to say it's only about 8% of the web is truly accessible or completely meets the WCAG guidelines, at least the 2.1 was the last, and now 2.2 is starting to roll out, and we're seeing a little bit of a change as it relates to the way that that's starting to play out across the industry. Now, I have seen some of the consumer attorneys out there starting to build their offensive strategies towards kind of an attack methodology there. But I think from an industry standpoint, the most important part is making it accessible for people to actually make payments. Like, you can't just discount this whole section of society and be like, well, I don't have to worry about them going on and making an online payment, especially when we're seeing this massive increase post COVID of over 80% of the traffic going to collection agency websites coming specifically from mobile devices. That's a pretty significant lift. And so as we start looking at that and realizing how many of the payments are actually coming through without making a site accessible in these ways, we are kind of limiting the marketplace in terms of who can make a payment.
So let me touch on a number of the things that you just mentioned. Some of the case law is not limited to what you would think of some of the most obvious consumer facing entities, Domino's being one of them,
Mhm.
restaurants, Target through retail, others who've faced enforcement actions, but it has included the financial sector, right? The
Mhm.
Department of Justice brought enforcement action against Wells Fargo for the accessibility of their website and mobile app, right? So it's not
Mhm.
like our industry can rest easy and on our laurels because they're not focused on us, because they are.
Yeah.
And not only is it regulatory interest for enforcement actions, it's also a lot of plaintiffs' attorneys, what I would characterize as predatory plaintiffs, right? The ones
Mhm.
who are just basically surfing the internet looking for sites that are not compliant with the new standards under WCAG. And it's easy for them to do that, right? It's just click on different home pages. There's some free tools that you can download online that will give you an indicator about how compliant that page is. And to be clear, I work in this, space day in and day out. I have never encountered a website that was 100% compliant. It would be very difficult. And there's so many different areas, right? I mean, if you look at the
Mhm.
guidelines, you have to be thinking about having alternative text for images that would be read if someone is blind. You need to make sure that if you have videos like, consumer finance tutorials on your website, there needs to be closed captioning for those folks who are deaf.
Mhm.
For those who have physical disabilities, right? If you're having someone fill out a form, with how to make a payment, your name, your address, and your account number, that has to be navigable using keyboard strokes, not just navigating with a mouse, which some people with physical disabilities may not be able to maneuver. So you have to be thoughtful in so many different areas in order to comply. And if this is not a strategic effort on your part, you could very easily face, a bunch of these. I don't want to call them all nuisance litigation, right? but
Mhm.
they have a valid point. But the reality is, for our industry, we should be wanting to make our sites accessible so that people can make payments regardless of their situation in life and can resolve some of these financial burdens while they're dealing with whatever
Mhm.
physical burdens may be challenges in their personal lives.
So as you talk about like alternate text and the actual, let's call it the nuts and bolts of how to make that happen, it's been I've spent a lot of time actually doing some of that coding. And it's been my experience that the way in which accessibility works and the way in which Google search engine optimization works tends to be the same thing, meaning like Google also can't see an image, right? So if you're not providing that alternate text to explain to Google what that is a picture of, then it doesn't know what it's a picture of, and it's hurting your search engine optimization as well. So there is this like striking balance to doing things the right way, and it's things that you don't necessarily see if you don't need an accessibility tool to access the web. It's not something that you generally experience, and a lot of that is happening so much in the background that I think it's just easily forgotten, out of sight, out of mind. It's not something that you're dealing with, it's out of mind.
Yeah, the reality is the internet is certainly a complicated place, right? Some of these background functionalities that we don't think of much actually do matter quite a bit. Search engine optimization is one. But you look at some of the way just the internet works, referral
Mhm.
IPs, and how you're capturing that information, security systems, and other fraud detection tools that may be running that I'm a lawyer, right? So that are the things that I would think about on a day-to-day basis, but are critical to the functioning
Mhm.
of these various websites, which brings us to another topic I know that we were wanted to touch on, some of the recent litigation, recent regulatory activity around e-commerce, online tracking, and some of the state privacy laws and obligations that have arisen. And, the internet has worked the way that it works for the last, 20, 30, 40 years. And uh, I don't know that the folks who are writing policy understand how the internet works. And so
They don't.
there and and so they have these expectations around
Mhm.
things like global privacy control and how you're disclosing the cookies and pixels and other online tracking technologies on your site, and how you are able to provide choices to consumers to opt out of some of those things, and whether or not any of that activity constitutes wiretapping. I hate that word, with regard to the internet, because there is no wire, right? This is
Mhm.
not, we're not living in the 80s where we all have like big phones where
Hard
someone could
lines.
physically tap the wire and
Yeah.
listen into our conversations. That's not how the internet works, but we're seeing a flood of litigation around the idea that these online tracking technologies should be pursued under those old wiretapping laws. So there's just so much happening in this space. It all sort of involves data. It
Mhm.
involves the privacy and security of information. But without these tools, the internet and the e-commerce environment that we've created that we all benefit from might be at risk.
Well, the debt collection industry is an e-commerce business, whether or not we want to admit it yet. That is where we're going. And I spent a lot of my time at CRS starting off meetings that way and just saying, are you prepared to admit that we are an e-commerce based business with the volume of payments that are collected through the websites and through the portals and things? It's starting to become kind of hard to miss. But as we look at those e-commerce and we talk about the tracking technology, that intersection between tracking and understanding usage, right? It's hard to improve the consumer experience if you're not understanding how the consumer is actually using the tool set, regardless of whether or not you're tracking the individual, that balance between these privacy rules. And now we're starting to see these, the state level, right, privacy requirements. And when CCPA first came out, there was a massive flood of changes that we had to make to websites in order to make them compliant with that rule set. Feels like we're going to start seeing more of that on the state level in absence of any kind of federal privacy rule.
Well, there are some hopes, right? So there is the American Privacy Rights Act. It's a piece of legislation that has been proposed. It hasn't actually even been introduced yet. It's still in draft form,
Okay.
but it's the closest thing we've come to a federal bill that would include preemption of all these various state laws. So, I'm happy to come back another time when we see some actual movement on that bill, but there's some hope that there could be federal preemption of all this patchwork of state requirements. But in the meantime, for the collection agencies that may be listening, really the only statutes at this stage that you have to be thinking about from a comprehensive privacy standpoint is California
Hmm.
and Oregon.
Mhm.
Oregon has a very strange exemption, even weirder than California, with regard to how financial institutions may or may not be exempt. And while
Mhm.
some of your customers, FDI insured depository institutions, some of the credit unions may have very specific entity level exemptions.
Mhm.
It has a very GLBA structured exemption for other types of data. So, the types of internet online trackers that we've been talking about will almost certainly fall outside of that GLBA exemption unless you're specifically using those tools for things like fraud detection and ID
Mhm.
verification, stuff like that. But there's obviously other state laws, right? Like state laws pop up all over the place that could potentially have broader implications to how companies are able to operate online. One of those is in the area of artificial intelligence,
Mhm.
right? The uses of artificial intelligence for a lot of different functionality, whether or not that is, again, for security and fraud purposes, or whether or not that's for identity verification, or if that's for, profiling different borrowers for their likelihood to respond, say, at the beginning of the month when they first gotten paid, or whether or not we should leave them, or maybe it's, they get paid twice a month and you want to hit them at both those time periods, right? That type of data analytics and analysis was, I think before this current sort of hysteria about AI was sort of
Mhm.
like, automated decision making and algorithmic analysis. I mean, that's just sort of part of the industry. But now everyone's like, well, is that AI? And I'm like, well, you know, let's talk about definitions, right? So
Yep.
Colorado has a bill right now that defines artificial intelligence so broadly. They felt the need to add an amendment that says, hey, when we're talking about AI, we don't mean calculators. So
Oh, so
there's
they're
a
taking it to
chance.
a very extreme level in terms of anything that any kind of a decisioning tree at that point would become artificial intelligence.
Correct. So your TI-85 graphing calculator is out, but potentially everything else with regard to your decisioning model could potentially be in. So it's things like that.
Mhm.
These not just straight privacy laws that are coming out of the states, but these other sort of tangential data related laws that I think folks in the industry need to also be paying attention to.
I mean, the passing of something like that sounds to me like the fear of the Terminator, and I feel like that's an extreme way to say it, but I feel like you've got some regulators sitting there on a state level, literally fearing about Skynet and the Terminator coming, and so I mean, to so broadly have to be able to say, like, well, your graphing calculator is not included. I mean, consider the TI-85 was something I used 25 years
Mm-hmm.
ago, right, in a physics class. Like, that's not make it's not a decision making, and using decisioning trees. How else are we supposed to be able to move data through massive workflows and to identify or prioritize work without being able to use some sort of decisioning trees?
And that's exactly what I think some of these bills are looking at. They want to figure out whether or not there's some in their mind the machines. I get it.
Hmm.
This is the matrix in their minds. The machines are going to make the decisions that could have what they consider a significant effect on a
Hmm.
consumer, right? Whether or not they're gonna, owe more money or less money, or whether or not you're gonna make a settlement offer of whatever level of or amount, right?
Hmm.
These things are gonna have a significant effect on a consumer's, uh, well, financial situation, medical situation, personal situation, right? There's a lot of things that they're considering with
Hmm.
regard to how what they think of as AI could impact someone. And while I typically don't talk about this in these types of scenarios, what you were saying about Skynet is you'll see this crop up all the time where they say, you have to consider the human and ethical implications as well as like legal effects and things of that nature. I'm like the okay.
Must consider the human ethical side of things. Okay. I mean,
Okay.
look, I
Well,
understand when they say they don't want, black box decisioning for credit decisioning, or they don't want these decisions made in quote unquote the black box, that there has to be some level of transparency. But I think defining AI so broadly is dangerous in and of itself, because now you're trying to regulate something that you don't necessarily understand.
Right.
And
And that's not something we're seeing on the federal level yet.
mhm,
Right? The federal
yeah.
level has taken a much more cautious approach where they're like, we understand that there are efficiencies and values that
Hmm.
come from utilizing these types of technologies. And you don't want to stifle that and fall behind, China, others who are adopting this very, very rapidly.
Hmm.
But states like Colorado could have the unintended consequence of stifling a lot of this activity and causing undue burdens that they're not anticipating, just basically not just you know stopping some of these Skynet type envisioned systems, but some of the systems that have been existing for years with
Hmm.
great efficacy within the financial ecosystem, and all of that may potentially be negatively impacted by all this.
Well, you're going to negatively impact those that are on performing loans too, because if we can't decision these things and we can't collect, why lend, right? Interest rates have to go up. We have to offset our risk levels, and it becomes this, constant balance of back and forth. Now, from a, as we start thinking about the collection industry as an e-commerce style business, right? You've got the ADA to try and get more people capable of actually interacting with your site and making those payments. You've got the privacy laws and concerns that you have to kind of think your way through. And I think as financial services organizations, even as we think about an e-commerce process, right, sending out messages for abandoned carts and other things, now you have to tie that abandoned cart message back to your 7 and 7, because now you're communicating an attempt to collect a debt. And it feels like there's this big ecosystem of pieces and parts and data that ultimately needs to flow throughout your organization to be able to actively operate that e-commerce style business under the regulatory fabric of debt collection. am i
I
too am I
agree.
too far off there? Like, it feels like there, I mean, I guess I'm just restating the obvious here on some level, but I start thinking about the level of complexity that the debt collection industry ends up underneath in order to operate a simple business, right? If I want to sell widgets, I can sell widgets online all day long, but if I want to collect a debt, I'm treated completely and totally different.
Well, and I agree with that. And like I said, this is a strange time
Hmm.
when they want to see the benefits of technology, but they're also scared of it,
Hmm.
right? So, in the collection space, I mean, again, a lot of this has been around forever, right? You want to, test, you want to be able to track how many emails were opened, how effective were those messages, so that you can tweak future communications to make them something that people are going to open and see, read, and understand. I don't know that there's a regulator in the world who would say, we don't want your consumers to understand the message in your emails to them, right? Like, that type of improvement in your communication style is obviously something that they would want to promote.
Hmm.
But one that gets to the stage where that messaging is what they would consider a dark pattern, right? You've used the technology to manipulate the communication in some way to lead someone to believe they have to submit a payment of a certain amount. Um, so I just think that there are competing pressures, even on the regulators, who, again, I
Hmm.
think we both agree, do not understand the technology. But they understand there's different things they want out of that technology, and how to marry those two into a, let's say, achievable policy that the industry could actually follow is where I think we're finding some problems.
And I think it's going to continue to be an evolving process, right? I don't know that there's any simple solution to this particular set of problems. I agree that there needs to be some guidelines or guardrails in place to protect consumers in terms of some of the disparaging effects of automated decision making. And we saw that with the Apple Card and Goldman Sachs and the way that they were originating loans, right? Like, we've seen some unintended consequences from that side. And I think it's important that we maintain guardrails, but it'd be great if they were, like, interacting with and asking industry, what they're seeing, and kind of learning from that process in a holistic environment. I don't foresee that happening anytime soon. I feel like the regulators are going to continue to kind of run the path of what they feel is best, without necessarily fully looking at the unintended consequences that are bound to come from the application of that technology.
Well, and like I said, I feel like the CFPB, the FTC have been surprisingly restrained
Hmm.
in this
Agreed.
area. The CFPB has had a couple of different pronouncements in the AI space. Essentially, if you're going to have a AI chatbot, you need to be clear that someone's talking to a chatbot and not a person.
Hmm.
If you're going to be using these types of algorithms to make underwriting decisions, you need to be clear in your FCRA, ACOA, adverse action notices what the actual reason was behind
Hmm.
the decision, and not just say, "Oh, our AI told us," right? Like,
That's the
so
black box decisioning. That's exactly it. You're right.
exactly, right. So, like, what they have said has actually been quite straightforward,
Hmm.
and they have not gone broader yet. And I'm assuming they will at some point, but they haven't yet. The
Yeah.
FTC has also spent a lot of time looking around this. They had their AI summit last
Hmm.
year, and they've been looking at this in a way that I think is a little bit further along than the CFPB. They've been saying how the use of AI could potentially trigger their UDAP authority, unfair and deceptive acts and practices. CFP hasn't quite said that yet, but
Hmm.
I think there's a lot of interest amongst the financial regulators in this area. They just don't know what to do yet.
It feels like because the federal government tends to move a little slower than the state governments, that they may have or be forced to put more thought, time, and energy into it before making the pronouncements. I think some of the things that we've heard from the CFPB, for example, as it relates to artificial intelligence, is you need to understand your artificial intelligence, which I don't disagree with that statement at all, right? Like if you're going to use this tool set, you need to understand what the inputs and why it's providing the outputs that it's providing. We can't just like leave it to the machine. You can use it to automate some of those processes, but if you don't understand the underlying math equation behind it, that's probably not a good thing.
Yeah, the thing that worries me about that is, yes, the federal government moves a little bit slower, and I like it when they're more deliberative and they hear
Mhm.
from stakeholders and take into account different factors and considerations that may impact any sort of rulemaking or pronouncement by them. Relying on the states is dangerous, right?
Mhm.
Because we've got, you mentioned earlier the huge burden it was to try to comply with CCPA, but now the new California Privacy Protection Agency has already announced they're going to start a formal AI rulemaking this summer.
Mhm.
And if they come out with something that becomes sort of the de facto standard that everyone has to deal with, but it's let's say outside of what others would consider a normative standard, which is, I would not put that past California to do. Um, then you've got another huge burden that you've got to comply with for the California marketplace, which is, to be fair, the fifth largest economy in the world.
Mhm.
It's hard to ignore California and not consider that sort of what becomes the national standard. I like that in the world of state privacy laws, no one else has followed California's standard, right? Virginia was the second state to enact a comprehensive privacy law. They've pretty much all followed Virginia, not
Mhm.
California, which I appreciate. So, you know, California was the first with the data breach law, and now we have all 50 states with the data breach law. California loves to say they were first with their, first government agency entirely devoted to privacy, their California Privacy Protection Agency. So they like being the first.
They sure
But
do.
yeah, they do, and I'm hopeful that the other states will not necessarily follow in their footsteps. I mean, I haven't seen what they're planning to put out. There was a draft of their AI regulations that has been circulating, but that's not necessarily what will be in the final version. So we're
Mhm.
keeping an eye on it pretty closely.
Well, Kim, I could literally sit here and talk to you for days about data privacy, e-commerce, and ADA, but I really do appreciate you coming on and having another chat with me. I learned so much from each conversation.
It is my pleasure to be here, and if you'd love to have me back, I would love to be here.
Oh, you're definitely going to see another invitation here. I feel like as this federal privacy act starts to maybe take shape, and just kind of keeping our listeners informed on all of that and the so many other things that you are actively engaged in. For those of you that are watching, if you have additional questions you'd like to ask him or myself, you can leave those in the comments below. If you have additional topics you'd like to see us discuss, you can leave those in the comments below as well. And I will get Kim back here at least one more time to help me continue to create great content for a great industry. But until next time, Kim, I really thank you so much for coming on board and having a conversation with me today. I look forward to seeing you at an upcoming conference.
Thank you very much for having me, and I will look forward to coming back and talking to you soon.
Awesome. For everybody that's watching today, thank you so much for your time and attention. We'll talk to you all again soon. Thanks, everybody.